The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We have two more cases to submit. One without argument, Ronfeld versus Shelby County Mertu Medical Center is now submitted, and we'll have oral argument in Kirlin versus Monaster. Ms. Wyman, are you ready? Please proceed.
I represent Deputy John Kirlin and his wife Sarah, who were the plaintiffs and the appellants in this case. This case stems from defendants' claim that they are entitled to a summary judgment because the plaintiffs failed to file a sufficient certificate of merit affidavit in a 2020 case that was subsequently voluntarily dismissed in 2020, pursuant to 1.943, which this court has held is an absolute right of plaintiffs, is final, and terminates the jurisdiction of the court. It's important to note there's been no further action taken in that 2020 case. Everything that brings us here today stems from a 2021 case that was subsequently refiled. There is a line of cases on legislative interpretation stating that the Iowa legislature is presumed to know the law when they enact a statute. Similarly, the legislature is aware of the absolute right that this court has held is provided to plaintiffs under Rule 1.943 and its interpretation in cases such as Bernard. The legislature could have addressed this absolute right when it was adopting Section 147-140, but it did not. Therefore, it's reasonable to conclude the legislature had no intent to disturb or interfere with a plaintiff's absolute right that has long been standing and created by Rule 1.943. To conclude otherwise crosses the line into legislation. For example, recently, the Iowa legislature addressed the issue of qualified immunity for state and government subdivision in what was called the Black and Blues Bill. Knowing that there might be inconsistent or other provisions that might interfere with this legislation, they consciously chose their words. They chose to start off Section 670.4A1 with, notwithstanding any other provision of the law. The legislature clearly could have used this same language when they were drafting 147.140 Section 6. If it wanted to preclude a 1.943 dismissal in this type of case. The legislature chose not to do so, and the district court was not allowed to now legislate that issue.
The Bernard case distinguishable, though, as involving a different statute, 66811, on expert disclosures for licensed professionals, when that statute does not have a dismissal component built into it.
In the sense that the language in 147.140 is different, but again, the legislature did not choose to say, notwithstanding any other provision, notwithstanding this long-time standing 1.943 rule, we're going to say this absolute dismissal language.
Then help me make sense of why they would say dismissal with prejudice. I mean, we have to give effect to those words, right? We have to give effect to those words, right?
To those words. I mean, the purpose of the statute was to try to force plaintiffs to do the due diligence necessary to determine that a claim has merit before we instill a bunch of legislation or litigation. But the automatic dismissal has to do with, in most cases, in most of the cases that have come up here, have to do with whether or not a certificate of merit was timely filed. In this case, it was timely filed. The issue was substantial compliance. That cannot be automatically dismissed. Substantial compliance is a subjective standard that requires an analysis by a court that actually has jurisdiction of that issue. That never happened in this case. There was no analysis done of the subjective nature of the substantial compliance with the certificate of merit that was filed. In this case, the conflict between plaintiffs' absolute right to dismiss their case and the defendant's now claimed right to a dismissal with prejudice in 147-140 is not even the end of the analysis. All of the cases that the defendants have cited are distinguishable. First, the plaintiffs in this case did file a timely certificate of merit. The issue was before the district court, the 2020 district court, was whether or not that certificate of merit substantially complied with the statute. That issue has never been addressed by a court that had jurisdiction over the issue. Again, nothing else has happened in that 2020 case since plaintiff voluntarily dismissed it. Everything happened in the 2021 case. Second, all of the cases that
This is between the 2020 case and the 2021 case, as far as the claims.
omitted one of the defendants in the 2021 case. And then when we filed our certificate of merit in the 2021 case, we also used a different expert, partially for the reason that we found out our original 2020 case certifying expert had previously been represented by defense counsel Frank Harris. So we decided we should not use him again in our second case.
Actual claims, the claims were the same, but you had a different, you dropped one of the defendants, right? Okay.
Cases that are cited by the defendants in those cases took action. These defendants took no action. Plaintiffs filed their 2020 voluntary dismissal with prejudice. With prejudice. The intent of the plaintiffs to refile their claim could not have been more clear. They knew we were going to refile our claim. They did nothing. The Kirlin defendants failed to resist, failed to move to strike, to vacate, to seek any sanctions, or to otherwise seek any relief from plaintiff's voluntary dismissal.
Saying that the right to dismiss is absolute. Once that was filed, was there anything that the defendants could have done in the original case? In the original case.
That's the whole basis for why we're here. They now claim that they had a substantive right that had attached to that voluntary dismissal, but they didn't do anything. They didn't do anything to bring that forth. They didn't do anything to object. They didn't move to strike. They've done that in subsequent cases, but in this case, they didn't do anything.
What is, and I know that's not the facts here, but would a motion to strike have been of any value if, as you started your argument, the 1.943 dismissal is absolute?
Well, what they sought was an extension of DARA. So DARA was a case where the subsequent motion was to address sanctions that had happened in the same case. And they asked this court, this district court in the new case, to apply some sort of a DARA extended relief and ask them to say, not only can a court retain jurisdiction for the purpose of imposing a sanctions motion for conduct in a case, but to also then allow them to have this substantive right that they claim attached in the first case addressed by that court. But the problem is they did it in the 2021 case. They didn't go back to...
It strikes to me you kind of jump around a little between two arguments, right? One argument you have is absolute right, and it doesn't matter if they challenged the 1.943 dismissal in the earlier case or not, no problem. Your second argument is they needed to file a motion to amend the judgment and say it should be dismissal with prejudice rather than without prejudice or something like that in the original action, right? Right. That's your, so you say they have two problems. Is that your position?
Procedurally, first, it's the 1.943 absolute right to dismissal. The legislature could have overdone that and didn't, okay? So that being aside, what our district court did was apply DARA relief. So I'm addressing the fact that even if you say they did have a right or some substantive right that did attach in that first case, they didn't do it right. This is not relief that was anticipated by DARA.
Clear in DARA that you had to request sanctions within 30 days of the dismissal?
Time frame, but it was definitely in a close nexus and the same case. So DARA was a true retaining of jurisdiction. This district court didn't retain it, didn't reclaim it. I mean, he never had it. He claimed jurisdiction from a case that had already been dismissed, was as if it never existed, and according to this court, is unreviewable.
Kind of the opposing argument then, 147, 140 gives a substantive right for a defendant to have a certificate of merit that is filed within 60 days and that is the proper, that meets the requirements. And so when you reassert a second case, that you're stuck with that first certificate of merit. I think that that's what the argument is, and why is that wrong?
If that is the case, and if we're going to extend DARA to say that that did attach and that we can use DARA to have that district court retain jurisdiction to hear the
Jurisdiction, I'm just saying that once that, I think the argument is that that statute gives the defendant a right to a certificate of merit within 60 days of when they file their answer, that's a proper certificate of merit. And they only, and apparently only one. And so even if you dismiss that first case and then bring a second case, I think the argument is then that the certificate of merit still applies from the first one. So it's not so much retaining jurisdiction as tell me why the district court can't reach back and address a filing from the first case.
So again, I don't know how they get there under 147, 140. It's not clear in the language that they automatically get to have that. That's an after a dismissal sanction, right? This plaintiff's voluntary dismissal was not filed within 10 days of court. It was self-executing, and it was final when it was filed. To look back into that case, that's where they use the DARA case, right? And they're asking the court to extend DARA, which has never been extended. I mean, in all the years that DARA's been there, it has never, in 32 years, it's never been extended beyond sanctions, and in the same case.
Case have any relevance whatsoever to the case that we're arguing about now?
In our opinion, no. It was dismissed according to the law. It should have been unreviewable. It was a final dismissal, and no further action was ever taken there. If we were here on an appeal from that case that came up here, then we would have a totally different set of arguments. We'd be arguing about substantial compliance and whether or not the certificate of merit substantially complied, which is the argument we probably should be arguing. But we can't do that because that was not the case that was appealed. These defendants didn't do anything. They took no action. They asked for no relief until 4 months later we refile our petition, and then they say, oh, wait, we had a right over here, but you didn't exercise it over here. So if you had a right, you have also had a duty. You were obligated to bring that post-dismissal request for relief in that case.
That, you may be right, but on the merits, can you defend the adequacy of the certificate of merit in the first action? Was it deficient? And why not, if not?
So again, that is not the issue that's before the court, but to address the question, one, it was timely filed. That was never an issue. The only issue is whether or not it substantially complied. The argument was that our expert was not the equivalent of their treating doctor that was being sued. Our doctor was overqualified. Our doctor used to be that doctor. Our doctor went forward and had additional credentials. So the issue would have been, we needed to come in, we needed to have evidence, and we needed to be able to present a case in the court that actually had jurisdiction of that issue, and not in the later case. And we never. So we're looking back at that issue today. This district court also looked back on it, and he did it without a hearing. We never got to present our evidence on whether or not substantial compliance was met. And we basically were deprived of all due process on that issue. That issue has never been litigated. Never.
When a plaintiff dismisses without prejudice, let's say, and then starts a second action, does the time under 147, 140 just start back at 0, or does any of the time that elapsed in the first case matter? In other words, my point here is if the legislature is trying to say, okay, once there's an answer, there's a 60-day clock, there's ways to adjust that, but if you haven't adjusted that, we really want to bring this to an end. Can all that run in the first case, and then does it start over at 0, so to speak, when you bring the second case, or is there any interplay?
And it starts over by way of 1.943, which the legislature did not overturn. That case, that voluntary dismissal was self-executing. It was final. That case is as if it never existed. So how can we pull back filings that were done in that case in a new case? It's as if that case never existed, and it's unreviewable. The district court reviewed it. We're reviewing it again today, but it's unreviewable pursuant to the Supreme Court's law. So there's no way that the time, or it's no, and that was the problem in this case. The defendants treated this case like one continuous running of a claim. We had a 2020 case. It was voluntarily dismissed. It's unreviewable. It's done. But they just kept it running like this was all one continuous claim. It's not. It's a new filing. It's a new case. It's got new certificate of merit deadlines. We've met those deadlines again. This case has been over-certified. It's a clearly meritorious claim.
Thank you. You'll have an opportunity for rebuttal. Ms. Whitaker?
Good afternoon, and may it please the court. Counsel. My name is Bryony Whitaker, and I am here today on behalf of Dr. Barclay Monaster. Your Honours, this is a case involving allegations of medical malpractice against family physicians Dr. Monaster and Dr. Jones. Plaintiffs bring this appeal in an attempt to circumnavigate defendants' mandatory dismissal rights under Iowa Code section 147-140 created by their failure to timely serve a substantially compliant certificate of merit. To that end, counsel for the co-defendant
Determined that certificate of merit was not substantially compliant?
Yes, Your Honour, it has been determined in the second case by the Second District Court. And so, Your Honour, to that end, I will be speaking to the Second Court's jurisdiction on this matter, and my co-counsel will be speaking to the substantive merits of the case and the substantial compliance components. So, Your Honours, Judge Hooper had jurisdiction to rule on the certificate of merit issue for two reasons. And first, the mandatory dismissal right under Iowa's certificate of merit statute is substantive and is therefore to be interpreted strictly. And second, the requirements for dismissal with prejudice were fulfilled prior to plaintiff's voluntary dismissal, rendering it legally void. This meant that the Second District Court had jurisdiction to take judicial notice of defendants' mandatory dismissal rights under the Certificate of Merit statute.
The first case that the district court found the certificate of merit substantially complied with the statute, but then the plaintiff voluntarily dismissed the case because they wanted to recast their petition, maybe make it more specific, bring in different defendants, whatever reason. Could the judge in the second case then relitigate and redecide this issue and say, well, in the prior case, the district court got it wrong, there's a mandatory dismissal right, I'm just going to reverse what happened in the prior proceeding? Isn't that what you're arguing could happen?
Your Honour, the facts cited just then, we would contend are entirely disparate to the instant case. And this is because in this case, there was no order, there was no decree, there was not even a filing which stated that the case had been administratively closed. And so, as Judge Hooper cited in his ruling in the second case, there was no form of redress for our clients in the first case. And this is why we brought this timely in the second case.
Clients have filed a motion to set aside the dismissal, some sort of other motion after the fact in the first case. We actually have another case pending where that was done.
Your Honour, it would have to be a remarkably creative motion in the first case. And so, for example, a motion to reconsider. A motion to reconsider requires an order, a decree under the Iowa Rules of Civil Procedure. And so in this case, the proper application would be to bring it on the second instance.
Where is the sort of no going back point? So I think you would agree with me that if they filed this lawsuit in 2020, and it was before their 60-day window ended to get the certification filed, that they could have dismissed at any time. True?
Okay.
So it's only after that 60-day certification period that they can no longer dismiss voluntarily?
Yes, Your Honour, and this would be for two reasons. And first, as with all statutory interpretation, one must look to the plain meaning or the plain language of the statutes. And here it's clear, it's shall dismiss with prejudice. The language in the statute gives the court no discretion in this matter. And so, and the second one is to rebut plaintiff's earlier point about the legislative intent. And so if plaintiff contends that there is any ambiguity in this statute, one need only look to the legislative history of this bill, which contained, earlier versions struck down contained plaintiff's right to cure and a plaintiff's right to hearing. And both of those things were removed with the final version of the legislation.
Think of, and I think we sometimes say this, right, that the plaintiff is sort of the master of the plaintiff's own claim. And so long as they file their suit within the statute of limitations period, they can wait until, right up until the end. They can file it early, right? They can file it late. And it strikes me that that is sort of the backstop that the law puts into place to protect defendants in this situation. And so as long as there hasn't been some dispositive order entered, why is it that they can't dismiss and refile as long as it is within that limitations period?
I have 2 points in response to your question, Your Honour. First is, you're absolutely right, plaintiff is the master of their own claim, and so therefore they have it within their power to file a substantially compliant certificate of merit within the time frame allowed by the legislature. The second point would be, yes, we would contend that the mandatory dismissal right attaches. Yes, an order is required for the ultimate analysis, but once that right has attached, there's no going back. The buck stops there. And so in this case, because those events happened prior to plaintiff's voluntary dismissal, what would have ordinarily been an absolute right or rendered matters unreviewable.
Say the plaintiff files just a garden variety lawsuit. Defendant moves for summary judgment. The plaintiff misses the deadline for resisting the summary judgment motion, then files the 1.943 dismissal. Are they out of luck?
Procedural technicality that's not a substantive right, as is the case in this case. Here, the legislature clearly intended
The case. Rule 1981 says that the judgment sought shall be rendered forthwith if the pleadings, depositions, answers, show there's no issue of material fact. As shall, which you says is mandatory, creates a substantive right. So if the defendant was entitled to summary judgment in the prior case and the plaintiff dismisses voluntarily, which we've said is fine, how is that different than this case?
Your Honour, here, it's the order of events. And so, and even without the order of events, one could contend that Dara and Lawson v. Kurtzels would apply. However, in this case, because the automatic dismissal right happened prior to plaintiff's voluntary dismissal, this is...
Automatic dismissal right. Turns on the word shall, how is that different than 1.981 sub 3?
Your Honour, here, when looking at the plain language of section 147, and I see I'm running shortly out of time, so if I may briefly answer your question and then conclude. when looking at the plain language of section 147 and 140, there's two requirements. So one, they have not substantially complied with the statute, and two, that defendants have moved to dismiss their claims, which in this case, we did. We took affirmative action. Then to circumnavigate that, plaintiffs filed their voluntary dismissal and claim that this clock has restarted, which is not true according to the legislative, the plain language of the legislation. And so, to conclude, the plain language of Iowa Code section 147-140 gives defendants a substantive right to mandatory dismissal of plaintiff's case with prejudice. Allowing plaintiffs to subvert legislative intent by voluntarily dismissing the case would render the statute moot. And for these reasons, we ask the court to affirm Judge Hooper's order. I'll now yield to my co-counsel. Thank you.
I represent Methodist Physicians Clinic and Dr. Jones. I'll try and be brief. First, Justice McDermott, it's the filing of a motion by defendants that clarifies your question. Is it merely the 60 days and then we automatically get dismissal? No, but we filed a motion for summary judgment based on not just the non-compliant certificate of merit, but the failure to properly serve a certificate of merit. That wasn't passed on by the district court, but we have consistently argued. They never served the certificate of merit, either on our clients, the parties, prior to our filing an answer, or on us after an answer. It has been omitted entirely from the appellant's argument. But when we file that motion, that right attaches, and the plaintiff can't circumnavigate the legislative intent by filing a 1.943 dismissal. Yes, ma'am.
43 has been a part of our jurisprudence and a part of the legislative code through our rules for years, close to 100 years, back to 1940s anyway, when the rules were enacted, and even when the federal rules deviated and limited the voluntary dismissal without prejudice, we stuck to the 10-day, up to 10 days before trial. And so that has been a very definitive right. And so when the legislature wants to now change that, why is it that they, as the plaintiff's counsel, they didn't add language that said notwithstanding any other law, they didn't expressly identify 1.943 as creating a problem?
First, counsel's argument presumes that then, when a second lawsuit's filed, we cannot look back at the first lawsuit. That's simply not true.
To look back at a lawsuit if 1.943 dismisses the first lawsuit and it's as if it never happened. Isn't that what our cases say about 1.943?
Yes and no, because if you look at, for example, Fernald versus Hughes, 804 Northwest 273. I apologize, this should have been in our brief, but I found it when dealing with this issue. That's a case where the plaintiff in a personal injury automobile accident dismissed their action 11 days prior to trial, ostensibly because they wanted to evaluate their experts and get better experts. So we're in the same situation. 1.943 filed 11 days before trial. Within 6 months, they filed a new action, same claim, but they were outside the statute of limitations. So this case deals with 6.14.10. What did the district court do in that second case in whether or not to apply that savings clause to save the plaintiff's action? It looked at the first case and subjectively and critically looked at the plaintiff's conduct and said, you negligently prosecuted your case, therefore, this case is dismissed as barred by the statute of limitations. You can look at the first case and the hypothetical, putting aside that legal basis.
Statute that you're referring to, that's because that specifically allows you to look back at a prior case, I believe. Could you give me the cite to that case if it's not in your brief?
Northwest 2nd 273. The point is, you can look at the first case. Say, for example, hypothetically, instead of suing our clients again, the Kirlins sued their lawyers for failing to file a compliance certificate of merit. Say they sued them for malpractice. Would the court take the position that that first suit is not able to be used as evidence of their lawyer's negligence in that malpractice case?
Is the evidence that you're using the certificate of merit for. It's not that, that's a completely different situation where you're talking about what a lawyer did that was negligent in a prior case. Now, 1.943 says that the prior case ended. We have a new case which starts, why does the 60 days not just start over and you file a new certificate of merit?
Starts over, but the claim is the same. And you can't simply extinguish our rights that the legislature created to have a substantially compliant, conforming certificate of merit affidavit served.
Period started over.
They could file a new lawsuit. Yes, that's our point, is they can't file a new lawsuit because it was dismissed. It's no different than if
Without prejudice.
prejudice ending the jurisdiction of the prior court. What are we're supposed to, the very beginning of oral argument was, we can file a 1.93 dismissal and that ends jurisdiction of the prior court. Where am I going to file a motion? There's no case anymore. I can't appeal. There's no final order to appeal from.
Well, let's say day before trial, I file a 1.943, and it's just a garden variety case. You're defending it, and you're saying you just nothing you can do about it.
Different because in 1.943, there is that window. 10 days before trial, they can do it willy-nilly, but.
You know, I mean, you're saying 1.943 is not available under the circumstances of this case, and it's clearly not available under the circumstances of the hypothetical I've given. I mean, I think that
It's not. I think there, if you're inside 10 days, we can address it.
not available here.
Because we have a specific statutory right. It goes back to a month ago when I made this same point to you, Justice Waterman, in the other case, the Dickey case. We have a statutory right and a statutory right. How do you reconcile them?
Procedural issue of, it seems to me, I mean, and I'm not a very creative person, that I could have just gone under like Rule 1.102 and said, I want to move to modify this dismissal and make it a dismissal with prejudice. Couldn't you have done something like that in the first case?
Ms. Whitaker's point, those deal with orders. We're trying to modify an order. There is no order here. They voluntarily dismissed. That's the end of the case. And the point that I made, I know the underlying hearing wasn't transcribed, but I don't know why she dismissed. I could attach a nefarious motive in my mind that, in fact, she knew her affidavit didn't substantially comply, and that's why she didn't take it up in the first case, and they voluntarily dismissed to avoid the consequences of that. But I don't want to attach that.
And then the summary judgment case that we've talked about, the hypothetical, the rule says that a defendant is entitled and shall be given judgment as a matter of law. And our cases say that if a plaintiff tries to dodge an adverse ruling on summary judgment under 1943, then that's fine. It's an absolute right, and until the district court's decided, then the case can go on if they refile. So why is this case different?
It's different because the legislative intent has been made clear in this statute for these unique class of defendants. It is part of the legislature's clear intention. But it's a unique.
Statute says shall. 19183 says shall. So what is the legal distinction between our rule and this statute that creates some sort of different entitlement?
I think because it's I don't want to say special legislation, but it's designed as part of tort reform. It says shall upon motion be dismissed with prejudice. Those qualifications were all met here by us. To allow the plaintiffs to then voluntarily dismiss is an absolute end run around the legislative intent to protect healthcare providers from exactly what's happened in the Dickey case and now in this case of lengthy drawn-out litigation because the plaintiff didn't do what they were supposed to when they filed a lawsuit under a specific statute allowing for malpractice. And just to finish my point very briefly, I don't want to attach a nefarious intent when a plaintiff dismisses a case. I thought maybe they settled with the chiropractor and this case was going to go away forever. Why should my client incur more costs on a case that's dismissed to go ahead and file some motion in a case that's dismissed? Then when they refiled, we said, wait a minute, we have a right, you have a right, let's allow the courts to reconcile two incongruous statutes. But there is under 6141.0 the ability to look back and see that there was an error, we attached a right, and I'd encourage the court to affirm the court's decision in this case. Thank you all.
Plaintiff's voluntary dismissal was filed without prejudice. That's Law School 101. Everyone knows if you want finality, come back and make that a with prejudice dismissal. Justice McDonald, as to your hypothetical, I'd like to take that just a little bit further. Suppose I had a case where I did file a proper, timely, there was no objection to a certificate of merit. For other reasons, we exercise our right to 1.943 and dismiss our case. Then in the second case, somehow the certificate of merit doesn't get filed, on time, or it's filed on the 61st day. Are the defendants going to let me carry forward the certificate of merit from the first case and apply it to my second case? I don't think they're going to stand for that. I think they're going to force me to file a new certificate of merit in the new case because it's a new proceeding. The old case is over. It's not reviewable. So we shouldn't be bringing pleadings from that case into this case. One other point that was made, it was plaintiff's voluntary act to dismiss the first case. It wasn't Judge Hooper's voluntary act. It wasn't Judge Hooper's orders that dismissed the case. It was plaintiff's absolute right to a voluntary dismissal that dismissed the first case. Neither the judge or the defendants objected, asked for relief, asked for finality, asked for anything to happen in that case. And as we sit here today, still have never brought up anything in that case. It's done. It's over. It's as if it didn't exist.
As a factual matter, what was the period of time between the motion to dismiss and the voluntary dismissal filing?
That's a good question. I don't have that with me.
That if Judge Hooper had jumped in that intervening period and dismissed the case before you had filed your voluntary dismissal, that case would have been dismissed with prejudice?
That we would have had to have had a hearing on the subjective nature of substantial compliance. So we would have been entitled to a hearing on that issue before a proper dismissal could have been filed by the court. So if he had filed if he had filed a dismissal without a hearing, without evidence or any due process, we probably would have been here on that issue.
Follow the Vennard case. I mean, it's a similar statute. You have to have under that statute, an expert within 6 months. And whenever my recollection of med mal defense work, if the plaintiff lacked an expert by that deadline, the defense would move for summary judgment and game over with prejudice, unless, as happened in that case, they voluntarily dismissed. And we held in Vennard they could do that, absolute right. Is this case any different?
Different. And what that goes back to is that we want cases tried on the merits of the cases. We want plaintiffs and defendants to have their day in court. We want cases, we want the merits presented to a jury. We don't want to win on legal technicalities. That's not even fair. We want merits to be presented to a jury and let these cases be decided on the merits.
So that the legislature didn't want that. Suppose they actually wanted you to have your expert in the first case, and there's only going to be one opportunity to do that, so that before patients sue, they actually line up their experts in advance and they're ready to go, and that's their effort to reduce healthcare costs, et cetera. How would you have expected the legislature to express that in this legislation? What different words would you want?
Any laws to the contrary, and I can read you what Section 6 says, but I'm sure you're very well aware of what it says. But basically, it's notwithstanding any other law to the contrary, which would trigger, like, hey, we're saying 1.943 is contrary to this law. Failure to comply shall result in blah, blah, blah. So they could have, just like they did in other legislation. They've done this over and over and over. They know the law. They know this right exists. And to your point, it's been there for 40 or 100 years. They know that. When they wrote this, they knew that plaintiffs had that right. And they didn't choose to get rid of it. And I don't think a district court can legislate for the legislature.
Conflict between a pre-existing statute and a new one that You're saying the old one wins unless the legislature says notwithstanding?
Overrule it unless they say, we know this exists, and we're going to say, despite that case law that's been there for 100 years, here's the new rule in these limited set of circumstances. They could have done that. They didn't do it. And it's not proper for a district court to now legislate what the legislature didn't legislate. I'm out of time. If I can just briefly conclude. For the reasons stated above, the district court erred in granting these defendants, both of them, a motion for summary judgment based on relief on a motion that was not before this district court. They granted the defendants relief that they failed to seek timely in the 2020 action. And this decision should be reversed and remanded to the district court so that we can have a trial on the merits of this very important medical negligence case.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.